I'd like to welcome you to our annual dinner to celebrate 53 years of civil liberties advocacy in Australia. I'll now invite Stephen Blanks, President of the New South Wales Council for Civil Liberties, to step up to the podium and say a few words.
Well, thank you, Pauline, and welcome to another grand dinner for civil liberties. And it's fabulous to see you all here tonight. I acknowledge the traditional owners of this land, the Gadigal people of the Eora Nation, and I thank Chika for the welcome. We appreciate being welcomed to the Gadigal lands by the traditional owners. It's great to see you all here tonight, and what a great collection, wonderful collection of people you are. We have amongst you Senators Rhiannon and McAllister, Justice Wigney of the Federal Court, members of the New South Wales Parliament, David Shoebridge included. We have officers of various statutory authorities, the ACCC and the New South Wales Crime Commission, for example, but they're in their personal capacities here tonight. Meredith Bergman, I've seen. Former New South Wales Attorney General Bob Debus and Australian Home Affairs Minister. It's fabulous to have support of you and all of you here tonight for the cause of civil liberties. We have Paul Farrell, a star journalist from The Guardian, responsible for the disclosure of the Nauru 2000 Nauru incident reports. So just be careful, everything tonight is on the record. And thanks to Leslie Lynch, I think we have a statistically significant sample of Glebe residents here tonight. The ABS, I'm sure, would be interested in you. Leave your name and address for them at the door. And of course, I'm sure we have a couple of people from ASIO. If you wouldn't mind identifying yourselves, just so we know where you are and where you're recording. So I hope you find tonight's event worthwhile. Bernard Collaery, our guest speaker, is going to be fabulously entertaining. I've had the privilege of a few conversations with Bernard now, and I just know that he is going to say things which will be fascinating. I'm going to mention one other table that's here tonight, the Affinity Intercultural Group, a Turkish cultural group, and they are a group of people who are most concerned about civil liberties here, but also in Turkey. And the information they gave me this afternoon is, in the current purge that's going on in Turkey, 81,494 people have been purged, 40,360 detained, 20,000 arrested, 35 hospitals shut down, 113 news outlets shut down, journalists arrested, and so on. What's going on there is a human rights and civil liberties disgrace. And it's good to see representatives of the Turkish and Muslim community here tonight. I want to mention a few of the civil liberties issues that have been on, at least on my agenda over the last year, and as with every year, there is so much going on. But this year, we've seen the emergence of, I think, some interesting trends, and we'll see where they take us in the future. I think civil disobedience is back. This year we have seen the New South Wales government give police extraordinary powers to shut down virtually any kind of protest. In New South Wales, the right to protest has been protected by legislation, and that protection has been thoroughly undermined by legislation passed by the New South Wales government this year. The legislation is a disgrace. And the consequence is protesters and civil disobedience is back and is fashionable again. And whether it is lock the gate, and we saw this year the world's biggest lock-on Macquarie Street outside Parliament House, whether it's boycott the census because they want to retain your personal data in the most dangerous way, blockading WestConnex. There are so many things to protest against, and there are so many more people out there now, I sense, who want to protest to stop things. Another issue that's got on the agenda just now, racial vilification, free speech, Section 18C, and now, in the last week, you would have seen religious vilification back on the agenda. New South Wales Council for Civil Liberties has taken a stand for free speech. Racial vilification is right to prescribe, and the New South Wales racial discrimination legislation is too weak. It needs to be strengthened, but it does not need to be extended to protect religions from vilification. And you might have seen I had a piece in an opinion piece in the Sydney Morning Herald last week on that subject, which generated, I suppose all opinion pieces do, but it generates the most extraordinarily incoherent tweets from all sorts of odd people. We continue to see appalling human rights abuses in Australia and under Australia's watch. Nauru and Manus Island, Northern Territory youth detention, and many others. And what all of this indicates is what we need in New South Wales is a Bill of Rights. And the campaign for a Bill of Rights in New South Wales, I think, is going to get underway again, and it should get a lot of support. We don't spend all of our time complaining about things that are wrong. We've had some successes. This year saw the new Senate voting system, and at least the senators that have been elected are the ones that we voted for. We might not like all of them, but we have to engage with them because they got voted in. And I think that is a much healthier democracy when at least we're dealing with people openly who've been openly voted in. Finally, perhaps the civil liberties issue that was of greatest amusement to me, and it's not often that I get positive press in the Daily Telegraph, but there were a couple of occasions this year where I did. The one that amused me most was when there was a large article saying President of the New South Wales Council for Civil Liberties is a Sea Eagles supporter. And they had to explain to me who the Sea Eagles were, but it turned out that the New South Wales Police were talking about the possibility of launching an inquiry into match-fixing allegations, and decided to announce the possibility that they were thinking about maybe launching an inquiry, and as a result there was a lot of prejudicial reporting and criticism of the Manly Football Club. The civil liberties point is due process does not permit police to prejudice people in that way by saying they're thinking about launching an investigation. If they think there's a crime that's been committed, they should investigate it, and if they find the evidence, they should charge people. That's the way the police ought to operate, not in the media.
Good evening. We are delighted to welcome Bernard Collaery as our keynote speaker. Bernard has had a long and varied career and has been a dedicated advocate for his clients, many of whom have suffered human rights abuses. He has seen firsthand the effects of unchecked executive power. Much of Bernard's work has related to key civil liberties themes: assistance to those seeking asylum, protection of whistleblowers, respect for the rule of law, preservation of the right to free speech, transparency and accountability in government. Bernard has experience as a public servant in Canberra and Paris for the Commonwealth Government on a range of crime and terrorism-related issues. So it is appropriate that he will speak tonight about the position of professional public servants who are prepared to take a stand and speak truth to power. Bernard has practiced law from Canberra since 1979 and has an international profile in refugee and civil rights law, personal injury and criminal law. He has acted in numerous high-profile cases, including the Thredbo Alpine disaster, the Canberra bushfires, the fire on HMAS Australia, and in the UK in proceedings related to the deaths of military personnel in Iraq. His international human rights-related work includes refugee petitions on behalf of West Papuan refugees, petitions on behalf of South African draft resistors who had fled to Australia, advocacy for a return to democracy in Burma, and acting for Falun Gong practitioners. Over many years, he's provided legal assistance to East Timor. Bernard was legal advisor to the National Congress for Timorese Reconstruction in the critical period up to formal independence in 2002. Recently, his work relating to East Timor has received extensive publicity. Bernard acts for a former ASIS officer who claimed that Australia unlawfully spied on East Timorese negotiators during oil and gas treaty talks in 2004. In response, the Australian government and its agencies raided the former officer's home, subjected him to surveillance, removed his passport, and introduced new counter-terrorism laws which impose 10-year jail sentences for journalists who exposed security agency bungles. Acting in this matter has been at some personal cost and demonstrates just how difficult it can be to hold governments to appropriate standards of transparency and accountability. In Canberra, Bernard was leader of a community action group called Residents Rally for Canberra, which formed into a political party. They made Australian political history by being the first independent party to gain office since Federation. From 1989 to 1991, Bernard was Attorney General, Leader of Government Business in the Legislative Assembly, and Deputy Chief Minister in the ACT. He travels extensively in Asia, where he has a wide circle of contacts in government, academic and pro-democracy circles. Recently, Bernard has been a senior academic visitor at Trinity College, Cambridge. Somewhere in there, he has also found time to act as board member, patron and honorary solicitor for numerous charitable organisations, including the ACT Council for Social Services, the East Timor Relief Association and St Vincent de Paul Society. Bernard's topic tonight is Rule of Law, a Right to Truth. Please join me in welcoming Bernard.
Thank you, Therese. Your Honour, Justice Wigney, I see some retired members of the Judiciary. I recognise you too. Members of Parliament, distinguished guests who I include legal colleagues amongst, and dear friends. I'm hesitant to say, given that I'm reading so many redacted security documents at the moment, and also President Blank, but I do recognise Stephen, and I thank him so much for the considerable honour of inviting me here tonight. I'm humbled by the occasion. I should start by saying I think it's an understatement, Therese, to say that I've gained some understanding of the other side of the business. I was asleep in my room at The Hague on the 3rd of December 2013 when one of my colleagues banged on the door and almost broke in and said, ASIO have taken over your chambers. And so in those short periods before one was going to appear, I had this extraordinary experience of being both counsel and raided. Had many clients sit in front of me and tell me such a story, but I've never quite been faced with being all one in one parcel just before appearing myself. And also, I think it occurred to me very abruptly that, of course, I'd left a copy of my brief on my desk. So they had our brief. And one can't really comprehend that could happen in our democracy. Although I've been a firm supporter of whistleblowers, I've got to tell you that Witness K, who's the ASIS, very senior ASIS officer, was not a whistleblower per se. There is a procedure for those of us who deal with intelligence personnel's issues at times for those personnel to gain permission from the Inspector General of Intelligence and Security, who will allow them to elect to have a lawyer who's considered to be secure. Witness K had undertaken every necessary procedure and had written approval from the Inspector General, who I knew well, to consult me in relation to issues. That involves me signing certain acknowledgements of secrecy, and it involves Witness K in gaining explicit written approval for what the witness could do. And that written approval, in this case, included the right to approach any court or tribunal. It just so happened that how can you ever go to a court or tribunal if it's a criminal offence to reveal your name? You just can't get into the list. It's an extremely difficult process for our intelligence personnel who have something to say or a grievance. That was that situation. But it so happened, and I think it was notorious, that I was also personal legal advisor to the leadership in Timor, Chanana Guzmao, and it couldn't have escaped the Inspector General's notice that he was approving me to see a Witness K, who was clearly someone who had something perhaps to say about East Timor. Be that as it may, the baton was passed to me. I think the Inspector General reported to the then Foreign Minister Alexander Downer and to the Prime Minister, and clearly it might be a difficult proposition for the Inspector General of that day to take that grievance on. So it was passed to me. So the grievance meant that we needed to look for some redress and a tribunal. Well, there was a tribunal available, a confidential arbitration tribunal that could evolve out of the 2002 Timor Sea Treaty. That treaty, in normal, as commercial lawyers here understand, provides for arbitration provisions for disputes. When Australia negotiated and secured signature here in Sydney to the 2006 treaty with Timor, there was an extraordinary provision in it that said neither party, especially including Timor, of course, could ever question the treaty, could ever raise any issue, promote any publicity, make any claim in any tribunal or forum whatsoever. So it looked like a lockout. But there was one error the draftspeople made, which was to declare in that treaty that the 30-year term of the original contrived treaty that Timor signed on Independence Day 2002 would be amended to 50 years. that created an amendment of the 2002 treaty. The media don't really understand this, it's a bit complex, but the 2002 treaty was open to arbitration. So we called for arbitration. We met across the table to a very shocked group of Australian oil and petrol negotiating lawyers that I'm sorry about your 2006 treaty, but we're tackling the 2002, the 50-year term. There'll be no oil and gas left anyway, and we want to arbitrate this treaty. They put up some resistance and then finally realised they would have to receive an arbitration notice, which they did. The arbitration was set down for hearing. The evidence was clear-cut. There's no more fundamental breach of good faith in treaty making than to bug the other side's discussions, deliberations during treaty negotiations. Worse still, at those negotiations, Australia was the fiduciary partner in the joint development of the Timor Sea resources. It was a fiduciary that they were bugging. So it was no different from one boardroom in Collins Street, Melbourne, meeting with a fiduciary commercial partner and making sure that they first of all bugged the ante-room and the officers of the other side. So that's what we're up against. Australia had nowhere to go in that arbitration, and what did they do? Well, on our first procedural opening day, they raided my chambers, seized our brief, and then gratuitously trolled through 35 years of my correspondence with the leadership, all the work we'd done, my other extraneous files on our other civil liberties work. They spent a day there coming and going with black boxes and recording machines, and interestingly asked the sole staff member we had left there, a young lawyer, whether there were any weapons present. They took her mobile phone, made sure they escorted her to an open toilet door, and harassed this poor young woman such that she wasn't inducted to the type of clients we have. It takes a while to make sure that we can deal with security personnel appropriately. She wasn't inducted. She didn't turn the certain servers and other equipment we have off because we'd never provided in our security measures for such an event. So it wasn't until I was woken in The Hague that I was able to frantically ring and try and shut down our servers, because I've acted in the capacity in which I'm acting for Witness K for more than 30 years, whilst I've been conducting civil liberties work. And I'll tell you why. The vast majority of intelligence personnel and defence intelligence personnel support East Timor. They read the other's mail. Why do you think there was such a breakout for Philip Dorling, the journalist, to write his stories and be similarly rated as me in 1999? Why do you think there were raids? And it was because the intelligence summaries that predicted, proved, established that there would be a militia pogrom in East Timor and killings on a very large scale were well known to Minister Downer. They were effectively suppressed. I'm constrained now by new laws in saying much more, but one day, when it comes out, you'll be ashamed to be Australians. Thousands upon thousands of people perished at a time when we were depriving our ally, the United States, of intelligence information, unprecedentedly since the Second World War, and tacitly allowing those events to take place. It's a great shame and a blot on our national history, and it'll have to be dealt with. So one of the issues that I hope to deal with in my lifetime is that we should ease our Australian conscience on a number of fronts. There are many fronts, as our dear friend Mr Madden talks, but one of the fronts we have to ease our conscience on is what happened to the East Timorese in that period when we knowingly allowed that to happen, and prevented President Clinton from knowing until he found out and asked for approval to move 15,000 US troops through Darwin. It was only then that we acted. And I hope one day I'll be alive for you to hear the full story of that scandalous episode in our national history. So all those papers of that period, all of the many jottings and internal matters they troll through in my chambers, all of those more than 30 years of working life for the Timorese. It was such an invasion of privacy. I subscribe to the Country Life magazine, the British one, I don't know why. I'd never be able to buy any of those country homes, but I bring them home from Cambridge, and Chloe told me, this is our staff member, that they were so dusted up by pulling every book out of my art library. Every single book was taken out of the shelves in their search, and dusted, and so dusted were they that they sat down, the ASIO officers, for a while and read Country Life. It's hard to, I must say now, it's, and then of course they were in the ceiling retrieving items. So obviously they'd bugged the chambers, and they bugged our house, and I can't look at an air conditioning vent anymore and lying in bed wondering. But in any event, it's a chastening experience to have that happen to you, and equally chastening to realise that the warrant that was used, which they refused to give initially, we had to secure it by discovery, was not issued by any judicial officer, any magistrate, any judge. George Brandis might be excused for thinking that there might be a couple of judges who I appointed as Attorney General who mightn't want to sign a warrant, but it wasn't a judicially approved warrant. It was a warrant signed by George Brandis under the 9/11 power he was given to combat terrorism. And so that man, colleague of Alexander Downer, who the Timor-Leste government had named as being party to with the head of ASIS, the Australian Secret Intelligence, we had named those two after a good deal of legal, and you can guess, settled advice, as being involved in a conspiracy to defraud. So the very person that Timor-Leste was accusing of criminal conspiracy got a warrant to get hold of the brief we had against him. How's that? Vladimir Putin? So it's a grim situation, and I'm reminded by Mark Davis sitting here, who's in our practice, that we live in dangerous times. We sure do. But I need to speak in a more organised fashion about the situation that confronts Witness K and the like of such persons who've broken no law, who in fact were informants as to breaches of law. And that's the worrying situation now. I'll remember when I was Attorney and Deputy Chief Minister, but Acting Chief Minister, when Bob Hawke wanted to start the first Gulf War. There was some convention that the Premiers and Chief Ministers are convoked, and he has to tell us. I wasn't sure where that convention was at, didn't have much time after the phone call. But the extraordinary untrammelled powers that have developed around national security. So I'm very pleased to see that there's a move in the Parliament to deal with just what is a threat to our national security. Now, there's some informed comment on that on our Law Office webpage if anyone's further interested, but in a distinguished audience such as this, I want to talk about the proliferation of secrecy laws. I want to highlight the concerns that public interest disclosure has to us all. I don't have to map that out, because the Australian Law Reform Commission spent 5 years examining and identifying and analysing all the provisions in Commonwealth legislation that impose secrecy obligations in respect of Commonwealth information. They identified 506 secrecy provisions in 176 pieces of Commonwealth legislation. Half of the secrecy provisions apply nowadays, as we know from the border protection issues, and as our Guardian representative knows, to consultants and contractors now are being swept into the net. So practically all of those people are now bound to confidentiality requirements just by doing some work for the Commonwealth. Around 30% of secrecy laws the Commission found apply to any person. It could involve a spouse of someone who talks in his sleep or her sleep. It could involve a journalist. Any person is caught by about 30% of the secrecy provisions in the Commission review. 70% of the statutory provisions create criminal offences. About 3/4 of those are indictable offences, punishable for a period exceeding 12 months. The remainder are summary offences. And the common elements of secrecy provisions by the Commonwealth don't include an express requirement that disclosure cause or be likely to cause harm. And the perversion of the witness K issue is that it was entirely against our national defence interests to bug the Timorese cabinet and deprive them of their revenue. It's well known their gas and oil will run out in about 10 years. It's a marine clay environment. They've got very little fertility and natural resources, and it's our interests. It's been the successive statements in defence white papers that a stable, prosperous island on all of our most important trade routes, a sentinel state, a lighthouse state, in deep water, I emphasise, in deep water, the only deep water near to Australia, closer than Albany, that can house a submarine. It was in our great interest to continue an effective working relationship with Timor and not to lead to their further impoverishment. So Witness K was truly acting in the national interest in revealing certain matters, and I can't talk about any longer, but you can see how perverse the secrecy provisions now operate. I won't get to Nauru yet. The Commission found that almost 20% of the secrecy provisions contain no exceptions or defences. 80% contain some exceptions and defences, but they only relate to people who are probably police seeking information from other agencies. It protects them. It doesn't apply to most of us. It's clear that those secrecy provisions are prolific, they're expanding, they're overtaking our capacity to know what our politicians do. And more importantly, as Senator Conroy will no doubt tell you, they're overtaking our capacity to raise genuine criticism of genuine matters that relate to budgetary constraints, costs, information concerning government contracting. And the more important our governments withhold information, the more important it is that brave individuals speak up. But the cost to them is immense. The raid on my office was ham-fisted and stupid and aggressive, intimidatory, but there's a great subtlety and a great pressure on younger persons, particularly sole breadwinners, who know of an impropriety, a serious impropriety, know of something where there is an immediacy about the health or welfare of a situation, a risk to the public. That person these days can very rarely speak up without knowing that the spouse will say, "Why are you home early?" Now, the raids going on in relation to the national broadband band leak will, I predict, be cloaked with a suggestion of national security, which the government just falls back on at every juncture, national security. Those matters need to be tested. In the 60s, when I lived at the Cross, for the raid that established the Council for Civil Liberties. All the go was public morality. Ministers could declare what was moral and what public morality was. We sort of worked our way out of that. We law students at the time were greatly taken with Wade's book on administrative law, discretions by police and ministers and other agencies were going to be narrowed. There was going to be judicial administrative review, and a great new era was opening. That's the mood at Sydney Law School circa mid-60s. And so we had a period of access and review, and then the counter-pull started, and we're into that now. We're into a very dark period where discretions have been widened, but at the same time re-established and protected from any form of review, and to which persons who speak of the exercise of those discretions can now face, in a vast range of offences, indictable prosecution for indictable offences and summary offences. It's an extraordinary, almost despairing image to me and to some of the other, looking at Alan Connolly down there, men of my age, who thought the 60s were going to shepherd in this opening up, this great time when we would have a more open society. I'm not here to speak so despairingly, but I want to tell you, we live in dangerous and very unpleasant times in our nation at the moment. Now, so there are subtle provisions that give no defence to journalists. They're very subtle, because journalists often receive information in a brown envelope. It's out there in the waste paper bin as a phone call. I mean, my staff used to get those calls. And we would rely on that information, and journalists can't now, because irrespective of whether they know the source or not, there's a reckless test, and the infamous Section 32P in the new Act that was added to the National Security review after the parliamentary review, and now really captures the journalism in a very serious manner. And I might say the initial provisions against the media in Turkey, I think, when I read them, I had them translated, adopted 32P and the provisions brought in by George Brandis. Someone says they did. Oh, our Turkish friends say they did. I mean, can you think of that? I mean, in our long march on civil liberties, many of you here, we would meet at civil liberty meets around the world. How many invites have you had lately as an Australian? And if you think we're not on the outer, just stay in Cambridge for a while like I do. We've become a repressive state. And it's sort of crept up on us, and we haven't been aware of it. We've been too busy at the Barbie or somewhere, and we've missed out on it. I feel so sorry for journalists who want to run a good story, because they risk their jobs. I'm not sure whether management will always back them. And I so believed over the years in that famous aphorism, publicity is the soul of justice. Is it working now? There are some great people like Farrell and the others around the place, but they're having the legs cut from under them. I want to give a boost to the medical profession who are speaking up over the immigration refugee situation. In particular, Dr. Peter Young, who in 2004 revealed and leaked medical records from the Manus Island asylum hell. A very brave practitioner. And I don't want to make it worse for him by saying any more nicer things about it. And no doubt we're being streamed live somewhere at the moment. You become almost psychotic, I can tell you. But we've been in this case we've had for Timor. We've been under surveillance, we've been followed, we've had our mail intercepted, we've no longer been able to use the email. We've had to send staff by plane just to deliver short notes to Chinana Guzmao. I've had to do extensive travel just because we can no longer use ordinary methods of communication. And the other matter is that for 10 months, I couldn't come back to my own country, I couldn't attend my practice, and I had to get all of our documents that were still secure and safe out of Australia because my legal team could not work in our own country. Now, Yolanda in our practice wants me to say this, and I'll read it. I think it's humorous. For those of you in the audience who are familiar with the TV cooking competition MasterChef, there are more steps involved in making a public disclosures application as a public servant than are involved in the grand final Heston Blumenthal dessert challenge. For those of you who are unfamiliar with the MasterChef final, Heston's Egg in Virtuous dessert challenge comprised 81 steps and took 4 hours to prepare. Have a look at the public disclosure rights, inverted commas, that are now in the 2014 Public Disclosure Act that the Commonwealth passed. What a joke. What a joke. We have no effective whistleblower legislation, and I'm really hoping that the new complement of federal parliamentarians can move the issue of protection for people who want to tell us that children are dying, people are being assaulted, and urgent requirements need to be met. It's a shameful situation, and I want to address that just before I finish. Now, if you want to disclose improper conduct, and I'm talking about principled disclosures and not vexatious ones, under the current legislation, you've got to go to your boss. And your boss acts as your gatekeeper and decides whether the disclosure warrants investigation. This is unbelievable. Have a read of it. And the principal officer decides to investigate, and then the officer has 90 days to complete investigation. Meanwhile, children are suffering. And you can also make certain applications after the 90 days, or you can go to the Ombudsman and so forth. It is simply, and I know there are statutory officers present, it's not adequate for immediacy of situations. We have in our country no effective means now, given the National Security Bill and the wide stretch of national security. I mean, you just know that Senator Conroy is going to be told that, well, the police can track him down even into the Parliament because as Communication Minister, he would have received a brief about cyber security. You'll see Four Corners on Monday, and around that time, I predict, there will be leaked the fact that the government had to raid Conroy because he's had other access and he might talk about cyber security, Chinese activity or something. That's how it's done, constantly, 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 when an honest, principled person wants to come forward in the federal administration. There's always some national security aspect to it. Now, and likewise, it's many years since the shocking mistreatment of children in Darwin came to light and was complained of. There was investigation, it went for a year. There are massive delays in that matter. I might say that was news all over Europe and England. It just didn't help us getting any more invitations to events, I can assure you. It's such a mess our country is in, and how did it happen? How have all these hundreds of pieces of legislation that every other minister got the parliamentary draftsman to draft for them so that they could cloak their activities and responsibilities as a minister? How did it happen? It crept up on us, I guess. Now, and in relation to border protection, just think of how wide those anti-disclosure provisions are. Quote, if it's reasonably likely to prejudice Australia's law enforcement interests, including its interests in avoiding international disruption to national and international efforts relating to law enforcement, or the integrity of law enforcement agencies' efforts relating to law enforcement, or the integrity of law enforcement agencies. What's that mean? It means that the Australian Government Solicitor's Office will have a blinding brief that you have no right and you had no right, and you were nowadays encroaching on law enforcement, the integrity of law enforcement. So you can't really criticise a federal police officer at the moment if you know that he or she's involved in an issue that could relate to those issues. How's that? Now, of course, the capacity to prosecute and the decision to prosecute are two different things. We must rely on the integrity of directors of public prosecution. And this is a further comment I want to make. All of us recall when we moved away from the police prosecutor. We moved to the independent directors of public prosecution. It was a great move, and I think I introduced the bill in the ACT, and we were going to have independent directors of public prosecution. They were going to be, and they were for a long period, and I mean no slight to anyone in this comment, eminent members of the criminal bar. Yet, look around and look how many prosecutors have been appointed as directors of public prosecution. Look around. Do your own research. It's easy to do. Some of them are most gifted, people of integrity, but the principle was that the directors of public prosecution would be persons of great eminence, persons of great independence, people like Nick Cowdery, Mark Weinberg. That generation has passed, largely. And you could check that. Make your own inquiries. And it's a worrying matter. So, right across the board, governments have encroached on our right to know what goes on, our reliance upon the rule of law, our reliance upon an independent judiciary, and a reliance upon a totally independent and eminent directorship of prosecution. Now, in saying that, I'm not in the least making any slight in relation to anyone who was a prosecutor when appointed or shortly before a prosecutor when appointed. What I'm saying is that the principle is that we were to draw upon the independent bar for those appointments, and that's not happened. Not happening. And I haven't got the time to go right across government and see what's happening. The law of defamation, you can see where the halters are on there. Joe Hockey got his award. Chris Kenny, a Conservative commentator, got a settlement from the ABC for a sketch. And even Greens Senator Sarah Hanson-Young launched a claim against the Zoo magazine for publishing a picture of a head photo shopped onto a bikini model's body. Personally, I'd settle for that at my age, but anyway, her claim was settled. And recently, when those 2000 Nauru files were released, Peter Dutton has said very menacingly, "I will not be defamed." So there we are. We've got a constant and imminent threat to knowing really the truth of decision making, whether decisions such as the national broadband are sensible. Our Prime Minister was insistent that the optic fibre be connected to copper into our homes. I think his emphasis at the moment is more on copper. But I think we should be able to review the things that might concern us and when principal individuals come forward. The scandal of 1999 has to be met. The scandal of trying to add to the impoverishment of the Timorese, when we, of course, as Australians, have an abundance of natural resources, abundance of gas and oil, has to be settled somehow. There are continuing issues in our society. We say one thing and do another. Australia supported demonstrably the right of white South African military deserters to dodge the draft in South Africa. I'm going back years, in the 80s, and and be granted protection and asylum. Well, when the first of them contacted us and came to Australia, all those words meant nothing. They were not given any form of refugee or humanitarian protection. My office ran safe houses. Recently, I got a huge case of champagne at the office. It was from a senior Australian television executive who was one of those draft dodgers that we hid years and years ago. They had to work their way into our system despite the fact that Australia was parading and posing in Geneva and in New York about our assistance for white South African draft dodgers. We just treated them miserably. All of the Timorese diaspora who were in Australia all those years, they were denied refugee status all the way to the end. They were not allowed to do English as a first language. So when it came, and this is the damage to our country, when it came for the Timorese to go to Vienna to try to negotiate the May 5 Accord, as it's known, and autonomy or independence, we didn't have a large body of educated Timorese. Angola did, Mozambique had, and the Portuguese had, but we'd not allowed them to have Austudy. We had done what's been done on the left bank. We denied them Austudy, we denied them English as a first language. The denial of status and the demeaning and the undignified treatment of Timorese over 25 years in Australia is yet to be answered for. And I dare say that if a public servant pulled out that file, he or she may be prosecuted. The policy files on that. Australia's archive policy, as Clinton Fernandez will tell you, is appalling. If you want some of the truths of the 1975-74 period, when Australian and British journalists were murdered in Timor, you don't get it at the Australian archives. You get it at the Royal Archives in Kew, in the United Kingdom. It's a treasure trove because the Australians used to copy their papers across, so you go there. But our country doesn't release them. Still to this day, those matters have to be searched out in foreign archives because we don't have a genuine a working Archives Act. Recently I went to the archives and requested files. I learnt from a source that within an hour or two the details of the files I was seeking had gone to certain quarters. It's shameful. We have a Putin-like control in our society at the moment, and both of the major parties are to blame for it. And finally, we need to launch a concerted effort to protect whistleblowers. We can't just have individuals like Dr. Peter Young out there. We need to form a concerted, publicly, funded by the public. We need to form a fighting group. I think Stephen said it's back to the barricades. Well, my response to your invitation, Stephen, which I take it to be, is that we should tonight resolve to start forming a fund to protect and act for, pro bono for most of us, principled whistleblowers. And that's the point I'd like to end on. Thank you.
As Bernard's speech demonstrated, the rule of law is being threatened in Australia by increasingly authoritarian modes of executive governance, police and secret police power. Indeed, the rule of law has had a rough trot in New South Wales since the election of the Baird government. The anti-protest laws and bikie laws have been at the forefront of a crackdown on civil liberties in this state. And in the shadows, we've seen a crisis unfolding in New South Wales prisons, with prison numbers skyrocketing on the back of a renewed crackdown on bail. Remand centres are filled to breaking point, and prisoners in suburbs not too far from here are being subjected to conditions not conventionally associated with first world nations. These issues require a stronger and more articulate response from within, both within our public institutions and at the level of grassroots politics. And Bernard Collaery has traversed both of these realms with great success, I think. And if we at the New South Wales CCL can aspire to anything, it is to do as Bernard did. To keep on organising, advocating and agitating for social change. So on behalf of the CCL, I would like to propose a toast to thank Bernard for a thoroughly inspiring speech. Thanks. And Bernard, if you'd like to come back up onto the podium here. Thank you. Thank you sincerely.
Thanks very much. Thank you.